Welcome to our media outreach platform. I'm Advocate Gaurav Gautam. Today we'll discuss about the dreaded scenario if a false FIR is registered against you. What will happen if, say, someone files a false FIR against you? Now, at the very outset, I want to make it clear that mere registration of an FIR against you does not, in any manner whatsoever, does not make you a criminal. Now, you need to understand what FIR is. Now, FIR is nothing more than a press start button for starting criminal investigation machinery as provided in Criminal Procedure Code for investigation into alleged criminal offense, and that too just for cognizable offenses. Beyond that, FIR has no power to make you a criminal in any court of law. Now, it's a sad state of affairs in India that any law which is made is always abused. Any provision which is made for one thing is always used for another thing. Same is happening with FIR. That today a tendency is rising among litigants to use FIR as a tool for bargaining. Now, this is something which courts in India are taking clear note of. They are well aware that yes, FIR is used as a tool for bargaining, and it's increased more and more now, even more than previously. Now, for example, in cases like matrimonial, if you have no ground to divorce your spouse, go file an FIR, create one. And the funny thing is that this system of false FIR is so deeply ingrained that it has almost become like a routine affair. It's like routinely done before you file a divorce petition, and the FIR, the allegations so made, are almost like all of them sounds like a Xerox copy of one another. Same allegations, same scenario, same facts, and same storyline. Now, same is happening with purely commercial transactions as well. As commercial as a contractual obligation is not met, for that too, now FIR is being used to tilt the balance of the case. Now, apart from these two established categories, that is matrimonial cases and contractual cases, FIR is being used to settle scores in business rivalry cases too, and to spoil someone's future prospect. And it sounds, bogus FIR sounds something like this. Now, commonly misused section will be writing and intentional insult to cause breach of peace, assault, criminal intimidation, and factually narration will be, something completely out of movies. So these FIR is just to settle scores. Now, what happens in case of, for example, in case of government employee, if an FIR is registered, he can be subject to disciplinary inquiry on the basis of that FIR, or is a person about to be selected in government service, his selection may be affected because of that FIR. So apart from that, it is now rising trend in intellectual property cases too to register an FIR, property tenancy cases. It has always been, and good old political FIR. And finally, ruling government, be it center government, be it state government, everyone loves abusing the FIR. Now, I bet no one can put FIR to more creative use than Uttar Pradesh government. For example, asking for oxygen supply on Twitter can amount to spreading negativity. God knows since when it has become a cognizable offense. The protesting in any shape or form in state of UP instantly amounts to sedition. For example, in Hadra's case, where there was a lot of protest, the state of UP filed FIR saying that there is an international conspiracy hatched by groups and individuals in foreign countries to defame and destabilize the state government, and filed as many as 19 FIR, including many charges of conspiracy, sedition, and all that. And the other states are no less. For example, ground reporting in J&K, according to state government, can amount to creating a negative environment for tourism. Then there is last year's infamous Takliki Jamaat case, in which Bombay High Court rightly quashed. Now, one of the outstanding features of all these bogus FIRs is that even though they are filed under cognizable sections, but their mere narration of the facts and the storyline, as is alleged, do not constitute cognizable offense. Now, the law on this subject is absolutely clear that FIR can be registered only in event of commission of cognizable case. Now, what is cognizable case? Cognizable case are those cases in which police can arrest you without warrant, and the list is provided in Schedule 1 of the CRPC. There is clear delineation of cases, in which case police can arrest, in which case police cannot arrest. It's clearly given, and police is well aware when they register FIR from the narration of the facts, it amounts to cognizable offence or not. Now, the moment FIR is registered, police has a strong weapon in its hand. It can arrest you any moment after registration of FIR, because law presupposes that FIR is for cognizable offence, and as I've said earlier, cognizable offences can be made without any magistrate's warrant. Now, this weapon is thoroughly abused by police officers. It's a major source of corruption, even in minor cases where there is absolutely no requirement for making arrest, because section 41 CRPC tells you under what circumstances you need to make arrest. So it gives you specific situation like the offence is very grievous in nature, or there is likelihood of tampering with evidence, or the person escaping away. If those conditions don't apply, a normal routine for offences less than 7 years or of less serious nature, what you have to do is you have to give a notice to the person to stand interrogation and to cooperate with the police. Now, what police does instead is to arrest on the flimsiest ground. So there is very interesting, I shouldn't say it funny, but it is funny in the sense that the allegation in the FIR, you can watch this video, this is of Mr. Shraddhanand Rebel. He's a social activist. The allegation made in the FIR against him was about writing some of the minor offences. Police came to his residence at 11 p.m, maybe 11:30, something like that, and they said, "We need to arrest you right now." Then when he and his wife said that this is a minor offence, you need to give us a notice, and I'll come and stand interrogation next day. The police officer went on to say that you are criminal because FIR is filed against you. He said that this over 10 times in the video. You are criminal because FIR is filed against you. You are criminal because FIR is filed against you, like that. And this second video is even more funnier, which police is trying to harass young couple, and police is interrupted by a lawyer, and he asked very specific question. He asked, "Please tell me under which government order, which GO, now young couple walking together is a punishable offence. Now please give me that written instruction on the basis of which you are trying to arrest these people." So as you can see in the video, the police starts slowly backing off and running away from the video, because inside their mind they know what they're doing is wrong, but they will not leave any opportunity to make an arrest, because that is a major source of corruption in India. And the superior courts in India, be it Supreme Court of India or high courts of the state, see false FIR and chances of arbitrary arrest by police as a source of injustice. So much so that Supreme Court of India in Joginder Kumar versus State of UP AIR 1994, placing reliance on National Police Commission's third report, went on to observe that arbitrary arrest is chief source of corruption in India, in Indian police, and stated that as much up to 60% of arrests made by police is either unnecessary or unjustified. Now, the obvious question that should be bothering you by now is, what remedy do I have once an FIR is filed? So, to be specific, you have two remedies before your case goes for trial. As you already know or may not know, that regular bail can be applied when court has taken cognizance, and that too after arrests. So what remedy lies before that? You have two remedies. First of all is 482 application for quashing FIR, which we are discussing right now, and we'll go through details. And the second option is to file anticipatory bail, which is our next upcoming video. So in this video, we'll be specifically focusing on what considerations are before court when it entertains an application under 482 for quashing an FIR. Now, if you have seen my complete guide to registration of FIR video, I have discussed all the provisions relating to FIR, and you may have noticed there is no provision in CRPC that relates to quashing of FIR. So if you are searching for provision in CRPC under which you can see quashing, you will not find any mention of the text saying that you come here and you can get anyone's false FIR quashed, or you can challenge FIR here and here. So this is something that later on courts had to deal with, and the provision that was relied upon by superior courts, you can say High Court and Apex Court as approved, was section 482 of CRPC, which reserved inherent rights in High Court, prevent abuse of the process of law, and to meet the ends of justice. So what it means for you is that in case a false FIR is registered against you, no remedy is available at district and sessions level. You have to approach the High Court in your state concern. So the first remedy itself for quashing FIR is before High Court. There's no remedy, absolutely nothing can be done at district and sessions level, and you have to approach High Court under Section 482 or through criminal writs. Now, grounds for entertaining such petitions were settled as back as 1960 R.P. Kapur judgment, but with time, the courts evolved. Court took more and more proactive role in entertaining such petitions, as much as in case of West Bengal versus Swapan Kumar Guha 1982. Court went on to observe that if false FIR is registered, it's not only within court's power to entertain such petition, but it is utmost duty of court to quash such proceedings. In judgment, it went on to observe, as you can see on your screen, if, however, no offence is disclosed, an investigation cannot be permitted, as any investigation in absence of any offence being disclosed will result in unnecessary harassment to a party whose liberty and property may be put to jeopardy for nothing. Liberty and property of any individual are sacred and sacrosanct, and court zealously guard them and protect them. So the attitude of courts towards entertaining such petitions evolved over time, and finally the law was crystallized by Supreme Court in Bhajan law judgment, which is the most important judgment on this issue. The full citation you can see on your screen, which is State of Haryana versus Bhajan law 1992, Supplementary 1 SEC 335. So this judgment laid down as many as 7 guidelines. You can say 7 tests which should be applied when to make a decision whether to quash an FIR or not. So these tests, these 7 principles that were laid down, I will discuss all of them one by one very quickly. So let's jump right in. The first guideline says that where an allegation made in the first information report or the complaint, even if taken at their face value and accepted in entirety, do not prima facie constitute any offence or make out a case against the accused. So this guideline says both about FIR and complaint cases. Complaint cases, if you want to understand, you can watch Mr. Ajit's video, very beautifully made video. He explained very well what is complaint case, what is police case. You can find his video on this channel itself. So complaint cases are basically those non-cognizable cases for which you have to approach magistrate. Police cannot register FIR. So back to the guideline. So it said, yes, whatever you have written in your FIR, I read it like 1, 2, 3, 4, 5 times, and all the facts, if I read it, they do not make out any case for commission of cognizable offence. Like, for example, say I am asking oxygen gas cylinder on Twitter from Sonu Sood for my family. Now, how does this narration of fact make out any cognizable case? In whatever manner it can be written, but this constitutes no cognizable offence. In such cases, court will proceed to quash such bogus FIR. The second guideline says that where an allegation in the FIR or other material, if any, accompanying the first information report, do not disclose a cognizable offence, justifying an investigation by police officer under section 156(1) of the code, except under any order of magistrate within the purview of section 155(2). So what it basically says that the allegations so made are not cognizable. Rather, what at maximum what they can be non-cognizable case for which a complaint case procedure is already given. So you need to go there. For example, for allegations like a case of criminal defamation, say public nuisance cases, or cheating case or forgery case, such cases are non-cognizable in nature, so you need to go to magistrate first. Now the third category of the cases are where the uncontroverted allegation, uncontroverted means I'm not disputing what you're saying, made in the FIR or the complaint, and the evidence collected in support of the same do not disclose commission of any offence or make out a case against the accused. So best example of this can be a case where in car crash somebody is dying and another person stares and does no help at all, does not call ambulance, anything. What he does is morally unjustifiable, but his actions do not constitute any offence under Indian Penal Code. Now next guideline, which is the fourth guideline, it is mere recital of section 155 of CRPC, which says that for non-cognizable cases only magistrate can issue direction to police for investigation. Police cannot investigate on their own. So even if you see the text, it's same is similar to what's written in section 155 CRPC. It goes on to say, where allegations in the FIR do not constitute a cognizable offence but only constitute a non-cognizable offence, no investigation is permitted by a police officer without an order of a magistrate as competent under section 155(2) of the code means CRPC. Now the fifth guideline is very important. I will read the text and then explain you. The text goes on to say that where the allegation made in the FIR or the complaint are so absurd and so inherently improbable that on the basis of which no prudent person can ever reach a just conclusion that there is any sufficient ground for proceeding against the accused. I give you an example. For example, someone gives somebody a loan and they are not paying. So a false FIR will be registered something like this. I went to Ramu Lal's home to ask him to pay back my money, and he abused me and he threatened me to kill. He gave me death threat, and then he took me inside a room, and he beat me for hours. I was subject to wrongful confinement and this and that, even though the Ramu Lal home is a joint home and he is living in a joint property, so there are 20 other people living in that house. Such kind of like fictional stories which are on the face of it very improbable. Now up next is those category of cases in which special legal engraft or a restriction has been imposed. For example, if you want to allege a corruption charge on an army officer or naval officer, you cannot do so in regular police station. Even in cases of custom laws, there also generally the FIR is not registered. For there they have separate procedure, they have separate court of law. So there is a legal restriction there under established procedures. For that matter, any FIR registered which is in conflict with such provisions will be quashed. Now the last category of offences are those offences which are registered with malice, taking revenge. The text goes on to say, where a criminal proceeding is manifestly attended with malafide and where the proceeding is maliciously instituted with ulterior motive for wreaking vengeance on the accused with a view to spite him due to private or personal grudge, which the police machinery is used to settle scores. Especially this happens in say like election disputes, election rivalry, and now these days even at the Gram Panchayat level this is happening. Now congratulations, for this you have completed all the major guidelines in Bhajan Lal's case. So now another flip angle that needs to be mentioned is that once the court started entertaining such petitions, what happened was that real criminals, like I shouldn't name someone, a real mafia started filing 482 applications. Even this benevolent provision was tried to be abused by real criminals. So if you want to understand the nitty-gritties of 482, you can watch this excellent video by Justice V. Ram Kumar. Excellent discussion about the scope and how it has evolved and what are the challenges in quashing criminal FIR. The final phase of you can say evolution of quashing petitions was that more check and balance were introduced subsequently. So one judgment that I wanted to mention that clarifies how the court must dissect the petition to find out if there is abuse of process of court or not. So is Pratibha versus Rameshari Devi 2007 Supreme Court judgment. In this case, what Supreme Court basically said that you have to stick to whatever is written in the FIR. You don't have the jurisdiction or the liberty to go beyond what is written in the FIR. So you can say it was a kind of like narrowing down of the scope of judicial exercise. The issue, to be exact, before the apex court was this, that whether the High Court, while quashing the FIR in exercise of its inherent power under section 482 of the code, was entitled to go beyond the complaint filed by the complainant. So what basically the High Court did was High Court relied upon the charge sheet that was submitted by police officer. Now the charge sheet originally is meant to be entertained by magistrate and is not written for High Court at that stage. So what Supreme Court observed, that High Court, while exercising, in this case, High Court, while exercising its power under Section 482, has gone beyond the allegations made in the FIR and has acted in excess of its jurisdiction, and therefore the High Court was not justified in quashing the FIR by going beyond the allegation made in the FIR or by relying on extraneous considerations. So, two specific things: you cannot go beyond what is written in the FIR, nor you can rely on any other stuff other than what's written in FIR. Now, before moving any further, I just want to very quickly make one issue very clear. I don't know why there is a whole lot of confusion around this, is that there is misconception in minds of clients and sometimes lawyers as well. Say if you approach High Court for quashing FIR, and while your application is pending before High Court, say a charge sheet is filed in the case. So the moment charge sheet is filed, your FIR quashing petition becomes infructuous. You cannot press any further. This is not the case. You can still get your FIR quashed if the ingredients in, say, Bhajan Lal case is applicable in your case. High Court can still quash even after filing of charge sheet before magistrate. So there is no limitation on power of High Court under 482 by mere fact of filing of charge sheet. These two citations, Anand Kumar and Mohta versus State of Delhi NCT 2018 case, and the leading case being Joseph Salvraj versus State of Gujarat 2011 7 SCC 59. These two cases are the landmark cases which clarify this issue exactly, very specifically, that filing of charge sheet does not restrict, does not take away the power from High Court. High Court can still quash. Now, one final case that I wanted to mention, I promise I will not drag you any longer. I was supposed to make this video in 10 minutes. It's already over 20. Is Gian Singh case. Gian Singh case 2012 judgment in which Supreme Court introduced compromise also as a ground for quashing FIR. It was great pragmatic thinking on the part of Supreme Court. It was open secret anyway that civil cases are being filed as criminal FIR in criminal cases. So what court said basically was something like this, that in cases where the case is standing on civil footing, like commercial case or partnership dispute or matrimonial case, family dispute, like that, in such cases, if there is a compromise between party, so that compromise can be acted upon by the High Court, and High Court in its inherent jurisdiction can quash such criminal proceeding or FIR if it is satisfied that yes, the compromise is genuine. Now, the exact text of the judgment read as follows: the criminal cases having overwhelmingly and predominantly civil flavor stand on different footing for the purpose of quashing, particularly the offences arising from commercial, financial, mercantile, civil, partnership or such like transaction, or the offence arising out of matrimony relating to dowry, etc., the family disputes where the wrong is basically private or personal in nature and the parties have resolved their entire dispute. In this category of cases, High Court may quash criminal proceeding if, in its view, means the High Court has the discretion, because of the compromise between the offender and the victim, the possibility of conviction is remote and bleak, and the continuation of criminal case would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim. So it just gave a window for settling civil dispute outside the court precincts and putting an end to this abusive criminal proceedings. So with this, we have discussed quashing of FIR. Now what remains is your second option, that is anticipatory bail, which simply put is pre-arrest bail, means a bail which is given before even you are arrested. And the magical thing about anticipatory bail is that it can be filed even before registration of FIR against you. So I will discuss all of that in my next upcoming video. And any suggestions you have, any questions you have, you can ask in comment section. And that's all for today. See you until next time.